as we continue on through our domain number 1, security and risk management, we're going to now move into a discussion about compliance, all right? Meaning that compliance in relation to governing bodies, the legislative bodies and standards bodies. Something that we kind of exposed ourselves to a little bit in the last section, but we're going to get into that in a little bit more detail in this section now as we move on. One of the important aspects of compliance is legislation and standards, right? Information exchange is an extremely important concept. It allows us to manage the flow of information over the internet, and it changes how organizations share their data. Specifically when it comes to something called PII. That is a term that you're going to have to be familiar with quite a bit when you get into the exam, this concept of PII. PII stands for Personally Identifiable Information. And we're going to see some references to that throughout the rest of this particular section here. But with regard to PII, the most important aspect of managing that is how that information is exchanged over public domain, specifically over the internet. There is an increased need to protect intellectual property, trade secrets, market data, personnel data, and so on, especially as more and more information, and we talked about this in the previous section, as more and more information gets exported to the cloud. Right? When we talk about cloud computing and the need for cloud computing and how businesses incorporate this concept in their environment today, the exchange of information is not simply isolated to my individual organization. It's being transported over public domain. So we have to protect those assets. Some cases, some new laws, regulations, communication methods, these are being created because of the ever-changing area of information exchange. So as data becomes more and more portable, and as more and more entities need to access that information, we're going to see changes in essentially how that data is managed. A legislative body or even a government agency is anybody that's going to regulate the processing and transfer of personal information. We have different legislative bodies that handle different business units and business sectors, and I'll talk about some of those different legislative bodies as we go through the rest of our discussion today, especially in this particular section. Now, a legislative body is different than a standards body. Standards bodies define best practices, but legislative bodies define practice and actually regulate the practice that we define as part of our standards body development. So a standards body is going to define kind of the best way to operate, whereas a legislative body is going to define the rules and regulations for a particular business sector that they have to follow to meet those standards. And we'll see that specific to different types of business verticals, right? Whether it's healthcare or financial or private sector, public sector, etc. Some samples, again, you're not going to need to know the specifics of these. When I mention a particular directive or a particular legislative body, it's a good idea to kind of have a general understanding that those exist, but you're not going to be specifically tasked with understanding those on the exam. Now, I will say this. You will probably be asked in some form or fashion, you know, what types of regulatory bodies are used in what types of verticals, so what types of industries, so and compliance standards that are used in particular business sectors. So we will talk about that as we get into that discussion a little bit later on. The DPD 9546EC, that's the Data Protection Directive. this is a European directive, baseline for national laws and logical legislative bodies for right to privacy. Australia has their Privacy Act. Argentina has a Personal Data Protection Law. Canada has the Personal Information Protection, Electronic Documents Act, and so on. In the United States, we have several different legislative and governing bodies that protect personally identifiable information, particularly based on the business sector. For example, in the healthcare industry, the Health Insurance Portability and Accountability Act, HIPAA, is a legislative and standards body. It's kind of both, right? We don't really define those two to be the same. Like I said, standards is kind of a way to operate. Legislation is a regulation or a law to operate by. But HIPAA compliance can be kind of categorized into both of those categories. The Gramm-Leach-Bailey Act, that's for credit-related personally identifiable information. That's one example of a legislative body, and it has to do with compliance in regards to personal, the use of personal information for credit card transactions or financial transactions. One that's not listed here is the Sarbanes-Oxley Act of 2002. This is what we call the Public Company Accounting Reform and Investor Protection Act, well, that's one way of referencing it, I suppose. The other is the Corporate and Auditing Accountability, Responsibility, and Transparency Act, or SOX, S-O-X. And you guys have probably heard of SOX compliance at some point or another, right? It's a federal law to expand the requirements for public company boards, management, and public accounting firms to act in a specific way, particularly when it comes to personally identifiable information. The SOX compliance was actually derived from this whole problem or issue that occurred with WorldCom. I don't know if you guys remember the financial fraud that WorldCom imposed on its customers, or Enron. But the bill is basically identifies the actions that the board of directors and the penalties and based on misconduct that's applied to those board of directors if for some reason they're not following particular guidelines, whether there be ethical, technical, logical, whatever. Some of the major elements of SOX would be accounting oversight. The auditing process has to be completely independent. There's a level of corporate responsibility. When we talked about due diligence and due care, they have to have specific financial disclosures about balance sheets, transactions, and stock transactions, etc. Conflict of interest needs to be avoided. Criminal acts and fraud accountability is there. White-collar crime penalties, corporate tax returns, fraud accountability, etc. So these are all very important concepts. But the reality is, this is really what all of these different bodies and regulatory standards relate to, right? It just happens that they happen to be specific to a particular vertical. I mean, HIPAA includes all of those other aspects that we just talked about when we talked about SOX, but it's more specific to protecting personally identifiable information in the healthcare industry, right? The Gramm-Leach-Bailey Act for credit-related activities, right? So it's, and by the way, this is not all of them. These are some of the main ones that we see. The Gramm-Leach-Bailey Act, that was named after I believe they were senators, or I don't remember those three individuals. I'm trying to think. Yeah, I believe they were Senator Graham, Leach, and Bailey developed this act. It's basically Financial Services Act, right? Ensuring that we have some sort of accountability in the financial institutions. And the specific regulations are directly related to consumer versus customer. The consumer is, for example, an individual that gets from the financial institution a financial product or service from that particular organization, whether it's for their personal use, their family use, to buy a house, or for household purposes. And a customer is essentially an extension of that. It's basically just a consumer that's actually developed that relationship, and they're protected by this GLB process, right? So a customer, as an example, a customer in this case would not be necessarily someone maybe using an ATM machine associated to that bank, but if they're getting a mortgage loan, or they're getting credit financing, or some sort of tax advising, then they would definitely become a customer, all right? So the relationship extends to kind of a more detailed relationship with the financial institution, where you're actually collecting a very specific, personally identifiable information. We see all kinds of regulations, even in the financial sector, right? PCI compliance, payment card industry compliance. Very, very important, especially when a lot of data security standards need to be applied to the payment card industry to protect payment card information. All right, this is what we call the Payment Card Industry Data Security Standard. It's basically just an information security standard to allow organizations that handle credit card transactions to follow kind of these mandated industry standards for protecting that information. All right, so there has to be some kind of security assessor that goes into that organization and identifies whether they they meet those PCI compliant standards. There has to be some sort of reporting compliance. There can even be kind of a self-assessment questionnaire that you can implement. We had to do that, for example, for our credit card processing company. We did a self-assessment, but it was just a questionnaire that identified how we handled that information. Now, PCI DSS is supposed to be implemented by anybody that processes, stores, or transmits credit card information. This was driven by both Visa and MasterCard, and they require their merchants to essentially validate that they meet these particular requirements. Again, another specific industry-related regulation or standard that has to be followed. Okay? Combinations of business and technology-related challenges exist in enterprise risk management, finance, operational risk assessment, and IT. Basically, that means that there's a lot of things that you have to deal with in order to ensure that you have an appropriate security posture. So in order to be able to deal with all of these different moving parts, you have to have kind of a methodology for dealing with this. And we're going to see a diagram that represents this concept in a little bit. Governance, risk management, compliance, all terms that you're going to have to be aware of for the exam. But these components are kind of cornerstones to managing risk and analyzing risk and applying solutions to mitigate risk and so on. So what is governance defined as? It is a business that focuses on their core that's supposed to say activities, identifies decision makers, determines accountability, and identifies performance metrics. Okay, so I read the bullet point, but what does it mean? It means that you have to have oversight, right? There has to be a process in place or some sort of input that identifies what the core operations are for a particular business, who are the decision makers, who are the ones responsible for managing that, not necessarily the subject matter experts, not necessarily the minions that are running around implementing particular controls or technology, but who's going to be ultimately accountable for ensuring that standards are being met for a particular business unit, okay? And performance metrics is a big key to this as well, right? Because performance metrics gives you a way of identifying whether or not you're compliant or not. So that's a very important concept. Risk management, we're going to spend a lot of time talking about risk management, the process of identifying, evaluating, remedying, and monitoring risk. Mediating, I guess, is a better term for that. And risk management can fall, we actually have a whole module, a whole domain assigned to evaluating risk management or identifying risk management. But the concept of risk management is a process, right? And we've already kind of alluded to what that process includes, and we've seen that a couple of times throughout the previous slides. Compliance, any kind of action that ensures that the behavior that the organization is involved in complies with the rules and the tools to verify compliance. So compliance is a cornerstone as well. Integrate these elements, governance, risk management, and compliance to make sure that your security posture, your security policies are effective. We want them to be efficient, and we want them to be basic, right? As basic as possible. That's a very important concept. As I mentioned before the lunch break, it is important that whatever policies that you've indoctrinated into your business are not so complex that somebody's not going to want to implement those policies. But they still have to be effective. They still have to be functional. So here's a diagram that represents this GRC overview. Remember, GRC is the governance, risk management, and compliance. These are the types of terms that they're going to be referencing on the exam. That's one of the things that you guys will see on the exam as well. In a lot of the scenarios that you're going to be presented with, the individual questions are going to reference in quite often these acronyms. And so they might say BC, or they might say IRP, or they might say GRC. You need to remember what these terms are. So it's always a good idea to kind of keep a list of all of these different acronyms and compile that list so that when you see those acronyms on the exam that you'll know what they're talking about. Okay? So governance, as I said, that's going to manage and control our enterprise, the responsibilities, the control mechanisms that we have in place. Compliance is going to ensure the compliance with laws, regulatory requirements, standards, and policies. And risk management is going to be able to identify our assets, assess the posture of those assets, evaluate, remedy, monitor risk, and define accepted risk. So if we're going to use risk acceptance, we need to define what's accepted. Okay, now, if you look at the arrows here and the control, compliance is going to feed into risk management. Because obviously if we're complying to specific policies or standards, that will hopefully reduce our overall risk. And then our risk implementation is going to identify whether we're complying to whatever standards that we need. All right, so all of these individual entities feed into each other, right? Governance feeds into compliance, compliance feeds into governance, and so on. All right, so this is a really good diagram that describes this GRC process. If you are in a specific sector, one of the things that you might have to, or you might be exposed to, is legislative regulation, right, or regulatory compliance. Security officers have to understand the laws and the regulations that are specific to their industry. For example, if I am a customer service-based organization, and my company is incorporated in the United States, but we have a call center in India, the laws and regulations for that business could be different than if I'm solely based in the United States, because the laws and regulations that apply in India may not apply in the United States. So as a security professional, it may be your responsibility to understand what those laws and regulations are, or at least consult with legal counsel or your staff to identify what those laws and regulations are, so because that's going to ultimately drive your policy. Governance and risk management process integrate those requirements. Laws and regulations provide specific actions for compliance or safe harbor. Now, let's define safe harbor, right? It says right here, safe harbor provision includes good faith conditions that may protect organizations from penalty of law or regulations. What does that mean? What does it mean? Any ideas? Anybody? Okay. I will tell you what it means, right? It's a provision in law that specifies, I'm trying to think about the best way to define this, but it specifies that certain conduct within an organization is valid as long as it doesn't violate a specific rule, okay? Here's an example. Let's say that you get a driver's license, right? And part of that means that you're not going to drive recklessly. So maybe it's, you're being told drive under 25 miles per hour, and that would be considered normal driving and not reckless driving. That's what we define as safe harbor. So if an accident occurs, or if something beyond your immediate control occurs, then you're at least protected by that statute, right? If it's, to extend the analogy, if driving over 90 miles per hour is reckless driving, that would be unsafe harbor. So meaning that if an accident occurs or if some event occurs when you're driving over 90 miles per hour, the liability that you have in relation to that accident is much more extensive than the liability that you would have if you were actually following the law. All right. Now, in the context of regulation, safe harbor and due diligence kind of actually fall together, right? Due diligence and safe harbor really combined together should result in adequate action, okay? Now, there are a lot of safe harbor provisions for things like ISPs, for example. Let's say, for example, an ISP is providing internet to a customer, and that customer is downloading copyrighted content and distributing copyrighted content. Well, with net neutrality laws and the types of laws that exist today, as long as the ISP is acting with due diligence, they can't ensure due care of their customers, but as long as they act with due diligence, in other words, being able to track those transactions, being able to monitor those transactions and provide information to law enforcement when necessary, they're not necessarily, the ISP is not going to be prosecuted under the Digital Millennium Copyright Act, DMCA, for those copyright infringements, because there are safe harbor provisions within DMCA that protect the ISP. Okay? The responsibility of the ISP is that they have some sort of reasonably implemented policy that provides for termination of a subscriber's account, suspension of a subscriber's account, who are repeat offenders or who have been identified as offenders in the first place. All right, so it's a concept that you definitely have to be aware of. Very, very important concept. Federal Information Security Management Act mandates specific actions and standards and requirements to ensure sensitive information and vital services are not disrupted, distorted, or disclosed. All right. So the Federal Information Security Management Act, again, is another regulatory compliance component that allows us to identify specific regulations to an industry. Okay. The act itself, specifically, that was developed in the United States, part of the United States legislation, and it defines a comprehensive framework to protect government information. So this might be something that specifically relates to you folks that work with Booz Allen and the government directly. It protects the operations, the assets, and its primary focus is against either natural or man-made threats. And it was signed into law, I believe, in early 2000. I don't remember the specific date, but I think it was either, I believe it was 2002, if I'm not mistaken. All right. Now, what does this particular regulation do? It assigns responsibilities to the agencies to make sure that the security of the data that's being the agency acting as a custodian of that data is protected, particularly with federal government data. You know, so it's going to require things like program officials, the head of each agency. They have to do annual reviews of their information security programs, and the goal is to keep the risks at or below some sort of specific acceptable level of risk. But it has to be cost effective. The response to those risks has to be timely and efficient, etc. There are 9 steps towards compliant with FISMA. You're not going to be tested on these 9 steps, but you're going to see, I'll go through the 9 steps right now, but you're going to see that there's a commonality with all these other regulations that we've already, in these standards that we've looked at in the previous slides. Number 1, you have to categorize the information that needs to be protected. You can't protect the information if you don't know what kind of information it is. There has to be a minimum set of baseline controls, meaning that there's a foundational security architecture in place to protect all of the assets across the board. You have to refine your controls using some sort of risk assessment procedure, meaning that the baseline is just kind of an initial set of controls, and then you need to go through and look at the specific information that your organization is responsible for, and you need to refine those controls using a documented assessment procedure. Then you need to document those controls. This is step number 4 in your system security plan or whatever plan that you're developing for that organization. Implement the security controls in your information systems. That's number 5. Assess the effectiveness of those controls. Remember, this is a living, breathing thing, and it has to continually be assessed and monitored to monitor the effectiveness of those controls as they've been implemented. So what do you think number 7 is? Make sure that you determine the risk level to the mission for that particular organization or the business in this particular case. And then authorize information systems for processing now that they've been secured. they can now start processing data. And then, of course, the last step, step number 9, monitor and evaluate the security controls on a regular basis. All right? So this is a particularly interesting aspect because it really applies to you guys and what you're doing in your day-to-day operations with the government. So if there was one that you would want to look at as a standard, this would be it, FISMA in relation to government entities. Anyway, all that being said, specific laws and requirements have to be cited in governance programs, and of course individuals that are responsible for maintaining that security need to be trained, and you need to be able to identify those training requirements and make sure that you're complying with those training requirements. Privacy requirements are very important as well. Privacy laws introduce complications for security professionals because it adds another layer of security that needs to be applied. Privacy laws are not quite the same as regulatory domains because privacy laws are often, I wouldn't say in every case, but it often are identified for businesses as a best practice operation. They're not necessarily regulated to those laws. Personally identifiable information is obviously very valuable to marketers, but the data possesses potential liabilities, right? There's a gray area. For example, Facebook and Google and these other big companies have access to so much personal information. They can make use of that information to enhance the experience of the user using the application, right? For example, the stuff that I see on Facebook all the time, you go into a business and all of a sudden you get a message that pops up on your feed that says, oh, it looks like you're at this business, rate this business. Well, that might be useful for that business. It might be useful for Facebook to gather that data, but that could be construed as violating your personal privacy, right? Because you're sharing your personal information with a public entity. Now, it's clear in certain industries where privacy is very, very important. HIPAA compliance, GLBA compliance, Sarbanes-Oxley, those are very specific regulations. The gray areas when you're dealing with, things that related to things like social media. If somebody posts something on their social media feed, is that really intended to be private, or is that information that's being able to be collected? All right. Personal data is defined as any information that relates to an identified or identifiable natural person. Okay? Meaning, some of the things that are very specific: Social Security number, driver's license number, home address, credit card information, etc. Other stuff that might fall under that category would be medical records, dental records, psychological records, criminal records, anything that's related to that individual. The data controller is mandated to implement technical and organizational measures against unlawful destruction, accidental loss, unauthorized alteration, disclosure, or access to that information. Now, I just read that bullet point, but think about that from the perspective of the medical industry, right? Now, when it comes to data, there are a couple of different components to data. There is the data itself, of course. There is the owner of the data. There's the user of the data. There's the custodian of the data. And we'll get into this in a little bit more detail later on. Every one of those individuals has a responsibility to ensure that that data isn't destroyed, isn't lost, isn't altered in some way, isn't disclosed, or isn't allowed access from unauthorized individuals. So every one of those data classifications, user, custodian, owner, etc., have a responsibility. The owner is probably the one that's least responsible, being that the owner is the source of the information. Right? The doctors have a requirement not to disclose personal information. My girlfriend works, she's a nurse at a hospital, a trauma center, and they go through compliance regulations all the time, an ER nurse. And, you know, I hear stories about nurses being sued or being fired because they're taking pictures of patients and sending them to their friends or whatnot. So, or they're disclosing stories about patients that come into the ER. That would be an example of either a user of the data or a custodian of the data. Individual rights often include the right to know who the data controller is, who's the recipient of the data, the purpose of processing that data, the right to have inaccurate data rectified, and some sort of recourse for unlawful use of the data, and a right to withhold permission to that data. All of those things make perfect sense. Individual rights in this case mean the person that actually owns the data. I have a right to know who's using my data. I have a right to know who's responsible for my data, who's receiving my information, why are they receiving it. If the data is not accurate, a credit report would be an example of that. Do I have a recourse for making sure that that data is modified correctly? And by the way, if none of these things happen, if a breach occurs, what's the possibility for me to act against that entity or various entities to either no longer disclose my data or some sort of legal recourse? All right? So that concludes that portion of the lesson. We're going to move on and take a look at some global legal and regulatory components, and then we'll continue on.